it stops, no one knows. We're going
Hi everybody, happy Monday. Welcome to a new week in Delphi. We've got Delphi going, we've got Daybell going, and Karen Reed started today. So opening statements and 2.5, I would guess, 2.5 witnesses. So they're back tomorrow. Man, oh man, there's a lot of stuff going on. So we've got some new filings today from the prosecution that we're gonna go over. But first, let me say hi to you guys. And then I know like Delphi's like popping today on YouTube. So there's lots of different people that are live or going live. So I'll do what I can to make it as short and sweet as possible and get you guys to go to wherever your next destination is. Give me 1 second. I have a middle child that needs me. Hold on. Alrighty, sorry about that. Hold on, let me get rid of this. Oh yes, Luthi, I have it. All right, let me say hi to you guys real quick, and we'll get right into it. Like I said, I'll do my best to wrap it up as quickly as possible, so that we can go on an adventure across the YouTube channels. So, hi, Carrie. I thought it was my glass. Was I blurry? I turned my camera off, so I've got these dang kids. You know, both boys are playing on PlayStations on the internet. So I'll leave my camera up. I tried to close every tab possible. It keeps telling me that I'm having like internet connection issues. So if it becomes an issue, I'm going to kick them off so that we can get through this. But right now I'll leave the camera off. Hopefully that will help with some of the internet stuff. Hi, Carla. What's up, Scott? Yeah, you were blurry with your camera. It could have been. Yeah, that's why I said freaking kids. Why are we rushing? Why not? I got because Bob's going live. HCC's live. I just feel like we don't need to rush, but I just felt like I should, try to get through it so that we could adventure out together. I know the prosecution tell defense what they are allowed to bring into for the defense of their child, their client. And I said their child, because now I'm thinking about my children. Hi, Dates. Hi, Chris. Salty C, 21 months. Dang. See, it's like a major delay. I clicked on that and it took forever for it to pop up. Bob may not go live. What's up, Rexy? Hi, Erica. Read the headline and was like, of course Nick wants to stop that. There's like 15 other way better suspects. Well, yeah, you don't want a jury hearing about those guys. Come on. Hi, Shibby. I stopped all my plans when I saw you were going live. I've been waiting for this. Aw, thank you. Whispers in the wood. All right, hold on. Let me scroll up here. What's up, Radar? Hi, Susan. Dina, Ramblin'. Digging those pink palm trees, T. Been in trial all day, Karen Reed. So excited to see T's live. Yeah, I was doing Karen Reed, and then on Karen Reed stops, I was doing Daybell. This was my destination. What you talk? Aw, no, take your time. Okay, well, yeah. I just, like I said, I wanted to make sure that I didn't take too much of your time if everybody else wants to, you know, travel around. So, but we're fine. I'm not in a rush, so I can always replay the others. Is this the case of the century? Truth or conspiracy? Is Richard Allen a scapegoat? Dun dun dun. Let's see that. Look at the delay on that. Oil slicks, desperation, and arrogance are about to be made super visible. BGOG, what's up, Shiraz? Rexy. All right, let me scroll by. Hi, BR. Hi, Johnny. My king of kings. Hi, Hillary. So what exactly is NM going to allow? Well, NM, as much as he would like to think that he runs the courtroom, he ultimately doesn't. So this is not uncommon. I mean, it's like, of course, he's gonna try to keep all of this out. So what we go over today is just what Nick is wanting the court to do. Now, that's different than what the court will do in most cases. Here, we always have that. Is the judge just going to be like, approved without a hearing, or denied without a hearing? But yeah. So this is, like I said, of course he wants all this done, but we'll go through it point by point, because there's a couple things that I found very intriguing, and we'll start with the motion. Actually, you know what? We'll talk before we even get started on that. So Judge Gull put out an order today. People were asking about it, but just to let you guys know, the order was specific to the Allen County Courthouse for jury selection. So she still hasn't put one out for the actual trial yet on what she is planning on doing when she gets to Carroll County. So just FYI, the order that came out today was for just the jury selection portion of it. So I'll touch on that first, even though that came later. I like to try to do them in order, but that one's kind of super simple, so I just figured we'll get it out of the way. And then we'll pull this up. Okay. And then we'll start with Nick's motion in limine, which, like I said, I'm not surprised that this is here. This isn't like earth-shattering is not really the right phrase, but this isn't just like a whole like, holy crap, I can't believe he's doing this. It's really not. I mean, this is really, I'm not surprised. What did I miss? I have my head in my oven. Aw, you're hanging out with Nick today, huh? Got your head in the oven? So, sorry, that was bad. You know, I think people take my bias about the attorneys to the extent of my bias about whether Richard Allen is innocent or guilty. It's just not. It's just, I mean, you can take it however you want to, but it's just not. I know how I feel. It should surprise you that he wants to stop. No, it doesn't surprise me at all that he wants to stop them from presenting a defense. No, I don't know. I'm not surprised by it at all. I totally saw this coming. He absolutely was going to try to hinder everything that he could. So we'll go through it. Make sure it's big enough for you guys. Now, it's okay. Like I said, we'll go through it a point at a time because I have commentary pretty much for almost every point. So, hi, Helen. What's up, not DB? It shouldn't be mundane. No, it is, but it is. I mean, as much as you don't want it to be, it is. So I even pulled up just for some comparisons because it's two big trials that you want to read through it together as a family. We should. He is unreasonable. Absolutely. The bigger issue is what she does with it. But I pulled up because, once again, I was just talking about the Karen Reed trial is happening right now. Last week, they had to go through all their motions before they could do the opening statements and get through that the Commonwealth, which is the prosecution, was, I'll move it over to that one, was essentially asking for the exact same thing. I'm not going to read through this one. This one has to do with Karen Reed, but this is literally the same thing. They did not want any evidence brought in that had anything to do with a third party. So the Commonwealth was asking for the same thing. And maybe that's why I'm not surprised, because I literally had just got done, reading through these and watching that motions hearing, which she ultimately, Judge Bev, for Karen Reed's case, ultimately ruled that they could not bring up the third party people and third party defense essentially during the opening statements. And if I was going to do a Karen Reed live tonight, this would be really what I would focus on. Was literally, if you guys did not watch it, here's what I tell you. Even if you only follow one case, it is. Hold on, I'm not there yet. Just breathe. Just breathe. Even if you just follow like one case, what I'm telling you, you should always do is listen to some of the main components of other cases, even if you're not interested in the context of the case. Because if you want to know like how this is going to work, it gives you a much better idea. So like for me today, my suggestion to anybody who wants to learn things would be, one, go and listen to Yanetti's opening statements, the defense team for Karen Reed. Just listen to that one and know that he was not allowed to bring up certain aspects of the third party defense. And he literally does his opening statement. I felt like he was like a surgeon. It was so smooth the way that he gets everything in that he wanted in there, but he does not pass the order from the judge. So it was just so, I was like listening like, ooh, that's like butter. So that's my advice to you on that one. Another one is that since we've talked so much about like geofencing when it comes to this case, is go listen to Trials Today. Happened to be the one in Daybell where they actually had the cell phone person, the cast guy on there on the stand talking all the data. So if you just want to learn things like that, I highly suggest just go find those things in other trials, whether you're even interested in the case, just so you can learn more about it. But Yannetti was, oh my gosh, Lolly was just boring as all hell. I was like, I think that he's lost the jury already and we're just starting. I was just so smooth. I was like around that. It was just like, ooh, that was beautifully written. Plus he's got way more personality than Lolly, but it is what it is. So anyway, so I just kind of want to give you this as an example. It's not uncommon that both sides are trying to get certain evidence. People are like, ooh, why does the I'm going in and out, am I? Okay. All right, give me 1 second. Okay, we're going to try it again. I close some more stuff and we'll see what happens. If I do start cutting in and out, I think my kids are about to hate y'all. I'm about to, but we'll see. I closed some more stuff, so let's see. I have a bunch of new members, you guys. BGOG, I swear you are already a member. Hi, Hillary, and thank you for joining. Salty C gave me her 21 months. She's showing off like woo woo. And then Rexy for 12 months. Love that. Queen Elizabeth, thank you for joining. Okay, so you guys didn't notice? Okay. No, you're good. I want you guys to tell me if I keep cutting out, because then I am going to go cut them off the internet. Ooh, Maligator showing up with 6 months. I can tell it's still got like a weird delay. Let me try to close some more things and just see if that helps at all. I don't want to close everything. All right. Okay. Well, I hate if it's like all bad sounding. Roblox's life, though. Well, the 15, I don't even know what the 15-year-old's playing anymore. He was playing basketball, but I think they moved on to something else. Sounds fine. Okay, we're going to keep going then. Queen Elizabeth, thank you for gifting 1 membership and welcome to whoever got the membership. Okay, so let me go back. What I want to say is it's not uncommon that each side is trying to prevent the other side from bringing certain things in. That's where I'm at with it's not uncommon. So just leave that there for just a hot second. Motions in limine are very common at this, especially at this stage, heading into trial. We're getting ready to, get into the nitty gritty about it. Now, there's things that he requests that, like I said, I have comments about each point, so we'll talk about them as we go through it. And what I think is more normal, what I think is not as normal. Then I also have, well, we'll get there. We'll go through that. Okay, so let's just start on it. Most of you guys have probably read it, but we're going to go through it and we'll talk about the points. The only one who really plays Roblox is my daughter, and she won't talk to anybody. So she's like, she's more stingy with her time than I am. Now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully requests that the court enter an order requiring the defendant or his counsels to refrain from mentioning in the presence of the jury during voir dire, opening arguments, presentation of the evidence, and closing arguments, any and all references to the following, either directly or indirectly. So anybody who thinks that this is, he wants it out of the entire trial, the entire thing. So a motion in limine, the most common use of it is to get the other side, to get the judge to exclude something from the other side. Hold on, let me see what Aaron said. Are you indicating that there are points in this that are more normal? I must have missed those. It all seems outrageously insane to me. I think that what I'm trying to say is the concept of motions like this are normal. I guess maybe I need to be very clear. Yeah, it's more, these are normal motions. Nick, on the other hand, is different. So that's why I said we're going to go through his points more at a time. Yeah, so he's saying essentially everything I list here, I don't want them to be able to talk about when we're picking a jury. I don't want them to be able to talk about during opening statements, during any of the presentation of the evidence, which is any person who's on the stand, whether they're doing cross, whether they're doing direct, and during the closing argument. So essentially anything that I list here, the defense can no longer talk about. So this first one was very interesting. Any comments about counsel for the state that constitutes a personal attack on the attorney for the state or comments on the role of the state's attorney? Yeah, there you go. That's probably the best way. I'll leave that up for a little bit. That's where I'm at with it. I'll carry a gifted membership. So I thought this was funny because it's like, so first of all, the defense is not allowed to pick on me. And judge, I need you to make sure that there's an order that says that he's not allowed to pick on me. So don't let them say anything about me and what kind of, like, how I do my job. Don't let them tell the jury anything I do wrong, because it's a personal attack if I do anything. Now, hold on real quick. Sorry, guys. Hold on. Stop poking your brother, Serendipity. Stop touching your brother. And they like, I could see like Baldwin or Rosie like put their finger in Nick's face, and they're like, I'm not touching him. I'm not touching him. Is that good or bad? It's good. No, I don't know. They said it's fine now, so hopefully I closed more stuff. My husband was checking the internet for me. So anyway, so yeah, don't, Judge Gull, don't let them pick on me and say personal things about me in the courtroom. I don't know what he thinks that they're going to say besides that he sucks at his job and that he lied. So I think that would be the biggest thing. But, you know, that's his first concern. His first concern is any comments about him. Anything that he would deem as a personal attack. No fear boners, I guess. Any comment which constitutes the personal opinion of defense counsel about any evidence, witness, outcome, or penalty. So any comment which constitutes the personal opinion of the defense counsel about any of the evidence, they can't have an opinion. They can't have an opinion about it. They can't have an opinion about the witnesses. They can't have an opinion about the outcome of it. And they can't have an opinion about the penalty. They have, essentially, you cannot talk bad about me, and you have, you cannot have a personal opinion about anything. Yet, this is why these are just so fascinating to me. And the hypocrisy, they literally wrote a motion where they straight out called the defense lawyers liars. Is he going to Delphi for the trial? Does anyone know? I'm going to try to go. My plan is to go the last week of trial. No, they can't have any opinions. No opinions. Isn't that like an important document that they can have an opinion? No, they're not allowed to have any. You didn't hear Nick said no. Like, he called them liars, and he's like, but don't let them say anything about me, okay? For instance, the defense counsel cannot vouch for the truthfulness or competency of any of the state's witnesses, including police officers or any of his own witnesses. So you can't have any personal opinion about the defense counsel. The defense counsel can't have any opinion about evidence, witnesses, outcomes, penalties, or any of the state's witnesses. They can't say whether the person's being truthful or competent. So essentially, when my guys get on the stand, I don't want the defense team to try to impeach them. They cannot call them liars. They cannot say anything bad to them. They need to be nice. Hi, Mal. So be nice to me, be nice to my witnesses, be nice to your own witnesses that you're calling that don't actually want to testify for you. So you're going to try to treat them as hostile, but you still have to be nice to them. You can't say that they lie. You can't vouch for how competent they are. You can't do any of those things. No talking about my friends. That's right. Number 3, any innuendo or inference that is not supported by admissible evidence. So here's where he's starting to get into, if I say it's not evidence, it's not evidence. Just because the defense thinks it's evidence doesn't mean it is. It's what I say is admissible evidence. So no talking about anything else besides what I say is admissible evidence, because they obviously can't admit any evidence because they can't have an opinion. They can't have any opinion here. So they're not, it's essentially like they don't have an opinion. They can't do anything. So it's only the admissible evidence on my side. Now, I don't know how, I'm sure that there's going to be people on the quote unquote opposition that are going to read this and be like, ooh, yeah, what's the defense going to do now, huh? And then those people are going to also be the same people who are like, see, the defense is going to totally delay. They're going to want to delay. No, Sleuthy, not according to Nick. He cannot. He cannot, because he's not allowed to have any opinions. There's no opinions about the witnesses. There's no opinions about the evidence. Nothing. And there's no innuendos or inferences that are not supported by the admissible evidence. Forget all the actual evidence and forget anything that the defense deems to be admissible or deems to be important and should be admissible. It's only what Nick says is. Now, obviously, we know that's not true. Ultimately, it's what the judge says. So that's why I say is, no matter what this motion is, the end-all be-all is going to be what she rules. Now, we all know, everybody in this chat knows, that's fucking scary. It really is. It really is. I mean, if you believe the person is innocent, if you believe he's guilty but still believe in his constitutional rights. What do you mean she has granted? She didn't already grant it. She did not. Are you just saying that because she's just her? Or did I miss something? She didn't grant this. No, she did. Bet me, I need a new laptop. I have no laptop for you. I have a desktop. No, I don't think she did. I actually watched a few pro prosecutors channels earlier. It was funny. like maybe not really funny involving the case, but just the spin they believe. She didn't. Okay, she will. I'm not. Well, that I'm not taking the bet on, because that would be insanity. It would be an absolute insanity to her to grant this without any type of amendments. There's just no way. There's no case. I mean, if she grants this, she might as well just go forward and deem him guilty without a trial. I can't even think of like the amount of his constitutional rights that would just be slaughtered if this was the case. So, yeah, so any innuendo or inference that is not supported by admissible evidence. Ultimately, like I said, the judge is going to be able to determine what's admissible and what isn't. He doesn't want them to present a defense at all. No, If she grants this, she put the final nail in the coffin. Oh, yeah. Then I just cannot see that she would be able to grant this without a hearing. They're going to have to be able to argue this. Now, when she'll have that hearing is a different story. All right, so let's see. The attorney cannot assert unsubstantiated allegations on collateral matters. These are so different case law. I have not had a chance to pull all of these up. I choked my own. So I don't know what each of them said, if he's actually quoting them correctly, and that's important, and you're going to find out why, because there's ones that he doesn't quote correctly. Attorney may not comment or allude to inadmissible evidence during trial. Yes, true. They cannot. They're not supposed to just start bringing up stuff that isn't admissible. And then this is the whole, if one side wants it and the other side doesn't, like they'll always say like they opened the door to it, so now we can have it, that kind of thing. So any attempt to indoctrinate the jury during voir dire by exposing the jury to a substantive issue in the case. Any attempt during voir dire to have the jury prejudge the credibility of a witness. So this is to go into, not to overly talk about Karen Reed, and I'm not trying to make this a Karen Reed live, but just for comparison purposes. What's up, Francis? For comparison purposes, just think of the opening statement where Yannetti is talking about certain key people and what he's going to present to them as evidence. Now remember, nothing that the jurors hear in voir dire, nothing that the jurors hear in opening statements, and nothing that the jurors hear in closing statements is technically considered evidence. But he still wants it to, like, does not want to give them anything, does not want the defense to be able to say anything about the witness's credibility before he can put them on the stand. Hi, Nancy. So any hypothetical questions that include facts that are not in evidence or questions that are not helpful in violation of Rule 705. Any attempt to introduce evidence of third-party motive that is not relevant and or the probative value is outweighed by unfair prejudice. Confusion of the issues or has the potential to mislead the jury in violation of Rule 401. So does not want the defense to be able to introduce evidence of a third-party motive that is not relevant. Now, here's the thing. This goes back to the whole who gets to deem its relevancy. According to Nick, anybody that is part of this third-party motive, the Saudi defense, is no good. Like they're not relevant. And or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury in violation of Rule 401. Now, there's 401. Wait, I was about to go into 404. Never mind. Before any such evidence may be permitted, the defense must show some connection between the third party and the crime. Yeah, well, that's what he thinks. He thinks the whole thing is prejudiced towards him and his investigators. So I would say, like, to me, like, this is very interesting. You would think that this would be something, this would be more along the lines of what the defense would be asking for from the prosecution, in my opinion, if that makes sense. Like, don't be coming out trying to, say any of his, his issues or any of, his history or any of his, like, just anything related to Richard Allen. You'd think that this would be like the defense asking the prosecution or the judge to stop the prosecution from doing this. So it's just kind of, that part's the odd part. Like I said, these are very normal. It's very normal that they would ask for certain things to not be brought in. Nick just asked for really weird shit. Yeah, you can't go saying that I was talking to people on the internet. Don't do that. Don't say that I was leaking stuff. They don't want things talked about in voir dire because the defense would be at an advantage seeing their reactions to the defense's important information, not just carrying into trial. Right. Well, they should still be able to ask like certain questions of, during voir dire of, can the juror listen to both sides of the evidence? Can the jury wait to make a decision? They're still going to be able to do things. It just, I don't know. Like I said, to me, it's just silly. He does kind of sound like a giant bear panties. Hi, C-Dub. Good to see you. I missed you. I went looking prior to 2019 to see my case how Nick tended to write up his motions, but I can't find any felony big cases. Well, he didn't have any. He didn't really do anything. Most of his stuff is drugs. He deals with a lot of drug cases. He doesn't really have any. That's why we've said from the get-go on this, he doesn't have the experience to handle this type of trial. And now he has Luttrell and Diener, but he didn't. He had Shane Evans, who also did not have the capability of handling anything like this. The whole point of why everything happened in October, like my thought process behind it, is because he had just gotten Luttrell. So people who were like, oh no, he was absolutely ready. In my opinion, he was not ready. He was absolutely not ready. He had just gotten a second chair. He didn't have one anymore. All driving infractions. Yeah, he deals with a lot of DUIs too. Well, he thought he was going to have a plea. I think he absolutely thought he was going to have a plea deal. And that didn't work out for him. So they don't want any confusion of the issues or the potential to mislead the jury in violation of Rule 401. Before any such evidence may be permitted, the defense must show some connection between the third party and the crime. Further, it must be a direct connection based on admissible evidence and not founded in hearsay, speculation, rumors, conjecture, or theory. Well, I think he wants it to actually be based on like admissible evidence. Well, the thing is, I don't know how to say this in the most simplest way. It's not the defense's job to solve the crime. It's the defense's job to create reasonable doubt and for the state to be able to get rid of the reasonable doubt. It's the state's job to prove to the jurors that this person on trial is the person who did it. The defense doesn't have to prove who committed the crime. That's not their job. They're not the investigators. The state requests such order in limine to include but not be limited to the following. Now, here we go. This part right here. He does not want them to be able to bring up Odinism, cult or ritualistic killings, Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Kline, Jerry Klein, and Ron Logan. So, any attempt to introduce the evidence of third-party motive that is not relevant or probative value is outweighed by unfair prejudice, okay? Confusing the issues or has the potential to mislead the jury. Nick wants it to include, but not limited to, these topics. So essentially, if they start talking about something else that he doesn't like, he wants to be able to include that too. Somebody just asked, who is Ned Smith? So Ned Smith was the guy who came in acting like the liaison, was going to get them, was going to get Elvis the attorney. He was the friend of them, of theirs, of the Fields. It is bogus. It's kind of crazy. I mean, it's his requests are just outlandish. But so he's saying, okay, hey, you need to be able to connect these people. You know, you need to have admissible evidence that's not founded in hearsay, speculation, rumors, conjecture, or theory. My 4-year-old granddaughter doesn't cry this much. But like I said, it's his job to bring in and prove to the jury that he did it. It's not their job to prove that he didn't. Like I think there's some confusion on why he thinks that. Any reference to an investigation this is the other thing. He also doesn't want any reference to an investigation conducted by Todd Click, along with any reports or investigative materials from Todd Click that is not relevant or is used for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401. Wait, so he can only use the investigators' information or the information of the investigators that Nick thinks is okay. He wants to get rid of anybody else who investigated the case. Why? Why? I want to hear someone explain this document reasonably. I don't want shit. Good luck. Like in like on a pro Nick McClelland side, I don't know if there would be any reason. It would just be like, well, Nick does what he wants. You know, Nick's the prosecutor. You can put in whatever he wants. Like I said, he can make the motion. Ultimately, the issue is going to come in with depending on what Judge Gull decides to do. That's where the real issue is going to be. Nick McClelland knows Ron Logan is the third-party defense because of the leaks from the judge's office, so he threw in Ron Logan. Well, I think what he wanted to make sure was if he was able to get any of these guys out, we know, the public knows, that their very first person that they put all the eggs in the basket for was Ron Logan. Then the next people was the Keegan Kline, Jerry Klein, which is Tony Klein. You know, they were really going, you know, hard at them and had their podcast shows out in full force. Give me 1 second, you guys. Okay, sorry about that. Shiraz, thank you. And welcome. Welcome all the new members. 10 of them. Hot diggity damn. If she grants this, the theory is correct. They are purposely screwing this up, knowing it will be an auto appeal, but it will take a while and give him time for a retrial. He's a Kim Kardashian way. Hey, Kaz. Yeah, but wait. They have every right to bring up Ron Logan. This was their that was who. Okay, so we don't want you to look at who Todd Click and Murphy and Ferenczi were actually looking at. We don't want you to look at them. But we also don't want you to look at the people that our own investigators were looking at. And then we don't want you to look at the person that the FBI was looking at. We don't want you to look at any of these people. Don't look at anybody else. Don't look anywhere else. And if they try to throw in somebody else, like the person with the pants in Florida, then we're also going to add them to the list. You know what I mean? Like, that's literally what they're doing. It's like, nope, not going to talk about anybody else. Any reference to an investigation conducted by Todd Click. Okay, so what about the investigation that was conducted by Ferenczi and Murphy? Do those get to come in? You could absolutely get a virtual hug. Yeah, nope, can't bring them up. It doesn't matter. The person, you have to say like the person who owns it. Well, I mean, he's not going that far. He's saying that he doesn't want the defense to bring up any of these people as any type of third-party motive without tying these people to the crime. Well, like you're saying, Ron Logan, it's his property. It's his property. So, I mean, he is tied to the crime. Whether he did the crime or not, that's going to be open for, you guys in chat. But he is tied to it. So that one's, fairly easy. Yeah, they're found on his property. No, he did? He did? I missed a super sticker. Oksana, I missed your super sticker. Thank you. And Dean, thank you. Thank you for being here. Thank you both very, very much. Remember, I'll just throw this out there for you guys. I told you guys, YouTubers get paid the following month. So anything you guys give me today, I'll get in May, right when I'm gonna head out to Indiana for trial. So just an FYI. What did he give him? What house plea agreement? Okay, well shit, now I gotta pull that up. I can't, the links aren't shit, where'd you go, Sleepy? The links don't show up. They're not like hyperlinks in StreamYard, so I have to like go over to the actual chat to find where she just put that in here. Now it's catching up. Hold on, I'm trying to grab it from the chat. Are you ready to get off the fence? Joanne, the problem is it's tough. It's tough. No, I'm not ready. I'm not ready to get off the fence. And that's why I was saying it earlier in the live. Like, people take my feelings about the prosecutor and my feelings about the defense team, and they make that I think Richard Allen is innocent or guilty. What happened, and this is exactly how I feel about Karen Reed, is I think that Karen Reed very well could have done it. I think Richard Allen very well could have done it. But if they did, then why in the world would anybody go to such crazy lengths to not present evidence, or hide evidence, or get rid of evidence, or in some cases create evidence? Why would anybody need to do all of that? That's the part to me that I just can't. I struggle with. For the travel fund, thank you. The world is mine. In your DM, I think I got it. It took my YouTube a minute to catch up. So the plea agreement for Woodhouse. The agreement is being signed by defendant, his defense counsel, and the prosecuting attorney. Shall be filed within time. The state and the defendant have made certain concessions and recommendations and agree that this agreement encompasses the following terms. The defendant has pled guilty to unlawful possession of a firearm by a serious violent felon, battery resulting in bodily injury to a public safety official. So a level 4 and a level 5 felony. If the plea is accepted, the court shall impose the following sentence. That the sentence as to count 1 will be 12 years, with 8 years executed in the Department of Corrections, followed by 2 years as a community corrections, if eligible. That the sentence as to count 12 will be 6 years consecutive. What kind of plea deal is this? Wow. Hold on. This is not a very good plea deal. That is not a very good plea deal. This is Brandon Woodhouse's plea deal that Nick and him signed off on. Yeah, he accepted it. He signed it. Sleuthy will drop the link in here again. And the gun, he had gone live and talked about the gun charges and said that it was in his dad's room that was locked. That's crazy. Hi, Sleuth Intuition. I'm not seeing anything right now about a plea deal. So, Sleuthy, will you drop it again in chat? Yeah, Woodhouse plea deal. Brandon Woodhouse took a plea, not Richard Allen. And I don't want to confuse anybody. The state has no objection to the court recommending that the defendant be able to participate in the RWI program. Upon successful completion of the RWI program, the defendant may petition the court for a modification of placement to community corrections if eligible. So essentially to rehab, no drugs, alcohol, enroll and complete a substance abuse program, take all medication as prescribed, and no new criminal offenses. That's tough. I don't know why he accepted that plea deal. I'll have to read it more in depth, but Adrian funds to be present in the courtroom to roll your eyes at the ridiculousness in person for so many of us. Here's the thing is, like, honestly, in going, I have to, I was telling my friend this the other day too. I'm like, I have to be of the mindset that there's a good chance I'm not going to get into the courtroom, but I'd rather take the trip while there is the opportunity to get in, because I have no idea what it's going to be like there. I have no idea how many people are going to try to get in. I have no idea who, like how she's going to pull people in. So I just feel like I have to go there with the expectation that, I hope I get in, and if I don't, then I don't. Who is Brandon Woodhouse? Brandon Woodhouse was the gentleman, a guy who has some of his own issues going on, and he was the one that Andrew Baldwin, the defense lawyer, had sent the accidental email to with what the thumb drive map of what they had received for discovery back in December of 2022. He had a YouTube channel. He did some videos on there. Most of them are gone. He ended up arrested, and so he's just been kind of part of the whole, kind of keeping an eye on what it was, like, what he ended up with and what he was going to get. Yeah, okay, I'll roll my eyes outside the courtroom. Well, absolutely. You know, most cases end in a plea deal. It's not, I mean, once again, not uncommon. It's just it's so weird that here we are. Did anyone here believe Brad Holder, Patrick Westphal, Johnny Messer, or Elvis Fields were even involved anyway? I think that there is a potential for a couple of those characters, yes. Do I think all of them? I personally don't. I have literally two working theories that one day before a trial, I'm going to go live and I'll tell you both my theories. My one where Richard Allen is the guy. If Richard Allen is the guy in my theory, he's the only one. He didn't do it with his friends and didn't do it with anybody else. I think he did it by himself. And then I have the opposite. You know, I go with my two working theories. I try to prove myself right and wrong on different aspects of things. So I have my working theory on whether I believe that this other crew of people, if it is the other crew of people, I don't believe it's all of those people. That's my thought. Oh, that guy. They messed with him for a long time. Yeah, he did some lives talking about the time that he was in jail and things that were done to him and things that were done to him by other people. He did end up filing a lawsuit that was settled, and they paid him. Yeah, oh yeah, here, nothing already said it. Never mind. Not news to you guys. Went after him for suing if they want, they get you some way or another. Just ask Jesse Snyder's family. So this is what, because for me, and I don't mean this doesn't have to be for anybody else. This is just for me. I have a set of questions that I need answered before I can go one way or the other. Because there's certain things, if it comes out to be one way, then I feel like it can't be that way. You know what I mean? Like if the answer is this, then it can't be that, obviously. Did the motion say the FBI open case seeking tip poster, which includes BG, cannot be brought up? Or we're still reading through that part. Okay, we'll get to it. Hi, Donna, by the way. None of the Odinis phones were there, or cars, or witnesses seeing them, etc. Odinis weren't involved. Well, I don't know. They have Elvis's phone was in Rushville the entire time. So that doesn't mean all right, I don't want to get too far down that hole. Rick, I think they will. I think they're going to. Yeah, so that's the other guy. That's Mitch. That's Mitch Westerman. Well, here's going to be another interesting thing, too, about the phones. We're going to get to it when we read through here. So anyway, they don't want anything to do with Todd Click. Nick says, no Todd Click. Nope, can't bring up any of his reports. Can't bring up any of his investigative materials. Nothing. Can't bring any of it in. So here is, the burden is on the opponent to show why it is relevant. And this is from Mullins versus State. This one I did pull up. Relevant evidence may be excluded. So here, relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. And evidence may be excluded if it confuses the issues. So I ended up pulling this one up because I don't know if you guys are on Twitter. If you're not, is this for jury selection or the trial? For me going out there would be trial. It would be the last week of trial. So I had to close all my tabs. So I'm going to go ahead and try to paraphrase what Michael Osbrook, and you guys, if you're following the case pretty well, I think everybody here probably knows who Michael Osbrook is. He actually is, so he's an attorney, and he tweeted something earlier, but because my internet's so bad, oh, I mean this filing. No, this file, he wants this for this includes jury selection, it includes opening statements, it includes evidence presentations, it includes closing statements, the entire time. He doesn't want anything talked about, any of it, at all. So he made a comment that essentially Nick did not read this document correctly. the Mullins versus State. I'm going to pull it up, and hopefully my internet doesn't go too wonky, so I can tell you exactly what it says. I'm here. I'm just pulling up Twitter. Like I said, I don't know what's going on with my internet, but it's got to be the boys. So Michael Osbrook says from Nick McMillan's filing here, where he quotes, "Burden is on the opponent to show why it is relevant." And he says, no, that's not what Mullins says, which we have up here. It actually states it is the responsibility of the opponent of evidence to show why relevant evidence is inadmissible. Essentially, the point of this is that Nick is now, and that's why I said I will end up probably pulling up most of the ones that are on here because I want to see if he quotes all of them correctly or incorrectly. But he essentially is saying, no, you're misreading the text and trying to fit it into what you want it to be. And that's just not what it is. Like I said, I haven't had a chance to pull up the other ones because now I'm very curious. And he puts a lot of citations in here for other case law. And I'm like, oh, now I don't even know if I can trust what you're writing here. Did Augur file a pro se motion for RA today? Please tell me I'm reading it wrong. I think you're reading it wrong. She just filed her appearance. She just filed an appearance, as how I read it. Somebody in chat who may think differently. Was there a recent comment from Librato regarding that bullet? I may be confused. The channel made it sound like Librato made a recent comment. So yes and no, Rebecca. I'll touch on this for just a hot second. Last night, Court TV, as they do with most trials, they go through and they do like a little mini documentary on everything that you need to know heading into trial. And since we have jury selection coming up here, in a couple of weeks in Richard Allen's, they did one for the state of Indiana versus Richard Allen. They played Librato's interview that we have already watched, but they played like some of the cut versions of it. And in doing so, one of the comments that he makes that I do not remember being in the ones that we ever watched. He makes the comment that the bullet was 2 inches into the ground. And we've talked about this a lot. Hold on. About the semantics of the word in the ground. Because every document keeps saying that the bullet was in the ground. Well, if the bullet is in the ground, how the hell did it get in the ground? If it just fell out of his pocket, like many suggest, how is it in the ground? So according to Librato, in the statement, it's an old statement, but newly released. If you remember, he did that interview with Barbara McDonald. So watch the Court TV little mini documentary that they did last night and most of it's very basic. Things that we already know, but obviously there's little gems like that they put in there. Okay, where was I at? So here's the next one. The 2 inches probably includes leaves and some dirt. But they say in the ground. They don't say under leaves. They say like in the ground. And all the court documents say, it's like one of the big ones that I have kept talking about, like the semantic of that word is important to me. And one of the reasons that I had talked to Steve from True Crime Web about doing the, like, can you tell if it's in the ground, then you should be able to tell how long it's been there. So here's another really interesting thing that he puts in here. He talks about any reference to geofencing. any reference to geofencing and or any testimony from Kevin Horan about geofencing or the findings from any geofence search that is not relevant or is for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401. Okay, Kevin Horan was an investigator and worked with the Unified Command based on their instruction. And he wants to make sure that, like, he's asking Judge Gull to make sure the defense can't use the information from one of their own investigators. So now you have Todd Click, doesn't want any of his stuff in there. Now you have Kevin Horan, who doesn't, they don't want any of his stuff in there. Well, we don't know. We don't have his experts yet, but I mean, it should be his expert. But I doubt it. I doubt it's going to be, because I think they're taking him off. And poor Kevin Horan, like when Richard Allen was arrested, like he was like, I don't know if it was Twitter or where he was like commenting about like how proud he was to have worked on this investigation with the Unified Command. And now he doesn't want any of that in here. We do have some experts, yeah, but remember the geofencing one, they even put 3 in there, and they're like, which one are you even going to use? We don't even know who you're using. So now he wants to kick out one of the investigators that was covering all the Odin information. Doesn't want the word Odin used, or Odinism used, or sacrifice, or anything along those lines. And also make sure that we don't use any geofencing. The geofencing that we gave you, that map that we told you you don't know how to read, we don't want you using that. What? So there's something up with the geofencing. There is absolutely something up with the geofencing that they do not want to talk about it. They gaslit that entire motion to the public to say, hey, you know, they don't know what they're talking about. And then they talked in circles in this motion. Then they called the defense liars and said they just are idiots and they don't know how to read the reports. Well, now they're like, no, we don't even care if you figure out how to read the report. We don't even and remember, okay, let me back this up a little bit, because this goes even deep. Remember when they were going to go talk to the phone people, or like their data people, and they said they didn't have any of these other reports. The prosecution said they didn't have any of these other reports, but right before they were about to go depose them, they handed them all of these reports, so they didn't even have a chance to talk to their data expert to know what the right questions were to even ask during the deposition. Do you remember that? So like they were trying to like keep all this stuff from the deposition, and now they're trying to keep it out of the trial. That's crazy. Why would all the geofencing be an issue? Because there's obviously an issue with where either photos were taken, where the video is taken, whose phones are pinging there, whose phones aren't pinging there that should be pinging there. There's definitely something going on. Well, I think so. I think so, Susan. Yes. I think it came from Kevin, but that's my thought. We don't have that in documentation. Right. Well, I mean, it's their constitutional right to be able to use a third-party defense. All right, I was just catching up on chat. So from any of the geofence search that is not relevant or is for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401, burden is on the opponent to show why it is relevant. Again, he's quoting from Mullins, which is incorrectly quoted. Relevant evidence may be excluded if if its probative value is substantially outweighed by its prejudicial effect. Evidence may be excluded if it confuses the issues. Okay, so the geofence map, essentially he's saying it's not relevant, and if it was to be brought in, it would be prejudicial, and it would confuse the issues because it obviously doesn't match what I'm trying to say. That's how I read that. That's how I read that. Any reference to any prior bad acts or acts of any witnesses that plan to testify at the trial that is not relevant to what the defendant is on trial for. That is not an act that is an exception to IRE 404B. So this is the bad act. This is like you can't bring in bad acts of people before, like, you know, when that person's about to testify. Yeah, he needs to show why it's irrelevant because he's the one opposing the relevant evidence. But he can't show why it's irrelevant because they just say, oh, it's irrelevant. You know, it's irrelevant. It doesn't matter. So any reference to any prior bad acts of any of the witnesses. So this one was interesting to me because, remember, he's the one who wanted to pull the employee records of Todd Click to try to show prior bad acts on Todd Click. So I'm thinking that he probably didn't find any because now he doesn't even want Todd Click talked about. Yeah, no, not according to Dick. Sleuthy, you can't do that. You cannot do that. So any prior bad acts of any witnesses, this will also come into play because, as we know, they talk about how many of these suicide companions were in, you know, that they're going to bring in to testify. They don't want them talking about them either. Hi, Julie. I think the geofencing would reveal the witness they left out of the PCA. Pick and choose. If that's revealed, it unravels. Right. I still like how Turk said expressions of Nordic belief stuff doesn't necessarily mean the killer was an Odinist. Right. That's how we do it, Susan. You just think about it, I'll say it. We're definitely mentioning that when you plan to have 10 inmates testify. Idiot. Exactly. Yeah, so it's like, nope, you can't talk about what these bad people did. But I mean, like, online, like, that's our first thought is, wait a minute, what did they do? What did they do? Like, who is this person even going to be reliable? So as long as, if it's not relevant to what the defendant is on trial for. Any reference to how the files were labeled. Okay, so here's some more, don't smack talk me and my team. Any reference to how the files were labeled that were handed over to the defense as part of the information and discovery provided to defense counsel by the state that are not relevant or that would tend to cause confusion of the issues or has the potential to mislead the jury in violation of Rule 401. Burden is on the opponent to show why it's relevant. Should I even go back and quote what it actually says? It is the responsibility of the opponent of the evidence to show why relevant evidence should be inadmissible. It's Nick's job to show why the relevant information, the relevant evidence should be inadmissible, is what Mullins actually states. This guy. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. This is exactly what he has to do. He has to prove the prejudicial effect of said evidence that he does not want in is outweighed by the prejudice. He has to prove that. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. He's the one opposing the evidence. Hi, Brian. New to this, but how is the bullet matched to Allen? If it wasn't fired, I thought I saw that it was an unspent round. Not a firearms expert, but I thought it has to be fired somewhere. So it's the tool markings. So the tool markings from the ejector extractor, one of those two. I know it starts with an E. You guys know how I am with the gun stuff, but it's the tool markings from the ejector or extractor that are supposedly being matched to Richard Allen's ejector extractor. It's not going to be pled. I do have a question. I shouldn't follow it up after that comment because I don't mean it towards anybody in particular. But there is a huge spiral of social media around Delphi with this impending trial. I don't know if you guys have seen it, but like the infighting is even bigger. Now I'm getting tagged on like community posts where people are like calling me a liar about stuff I haven't even said. I mean, it's the weirdest shit. So like you can tell that there's like this impending doom of like where are these people going to be relevant when this trial is done, regardless of the outcome. So like there's like a desperation happening on social media of we don't know what else to do besides Delphi, and now how do we survive? What do we do? How do we move on? Because all they've done for the entirety of their channels is Delphi. So there's like this I dare say unraveling of people because they don't have anywhere to go. They haven't looked at anything else. So I think that I don't know why, but it's like you can feel it in the air. Like people are just getting super pissed at each other for like nothing. Nick's case is weak and he needs to silence the defense in order to have a chance to win. If this case was so strong against RA, then who cares what the defense does? This report or this motion tells me there is nothing besides the bullet. That they have no other evidence besides the bullet. Because none of it would matter. Because the other big thing that they keep talking about that's going to sway the jury is all these confessions, right? All the confessions of Richard Allen. Well, they didn't have that when they arrested him. They didn't have any confessions whatsoever. They didn't have, these false confessions of I shot 2 girls and essayed other girls. They didn't have any of that. You know what I mean? So that's all post arrest. I'm telling you, this tells me they don't have anything else. And they do not want to take the chance that these sticks or anything to do with the Odins or anything to do with the legitimacy of a person like Todd Click, anything like that. They don't want to take the chance of these people coming in. And to me, it does. It stinks of fear. It really does. You can't see underground 2 inches with the human eyeball. This is either they got it wrong or it's just bullcrap. Maybe I agree. Right. I don't he said, so Labrato, who would know more than we do, and one of the reasons I can't wait for this fucking trial to happen, and I keep hoping that there is no delays. And as of right now, it doesn't look like everything that's happening right now is leading me to believe that we're going to trial in 2 weeks. Yeah, don't talk about anything else. Don't talk about anything else. They don't have anything but the judge's hammer. The bullet is nothing. I'm convinced bad testing. I think that there's a concern about the bullet because it's not an actual fired. It's not a bullet. It's an unspent round, right? I keep saying bullet, but that's not actually the bullet. Facts, DB Cooper, are not DB Cooper. Facts. Labrato. We know that there were people out there. I wonder if I can find that screenshot. Probably not in time for this live. There's so many fucking screenshots. But there's a screenshot of people who were out at the bridge and said that there was law enforcement. And this was days later, 6-7 days after the crime, that said that there was investigators out there with metal detectors. Right. Oh, yeah. If Gull grants this, the defense can't go to trial and will have to delay so they can contest to the Supreme Court. Unless for whatever reason they just have some other entire defense theory that they are like that they have prepared and they're just like, haha, tricked you, which I don't think they do. But fuck, that would be amazing. That would be hilarious to me. It would be hilarious. And they just walked in there like, we're not even going with that, you fool. You did all this stuff thinking we're doing this, and we're not even doing it. That's not what they're doing, and that's not what I even think they're doing. But I'm just saying, I think it would be fucking funny. So yeah, they don't want any reference to how the files were labeled and handed over to the defense as part of the information and discovery provided to defense counsel by the state that are not relevant or that would tend to cause confusion of the issues or has the potential to mislead the jury in the violation. Burden is on the opponent to show why it's relevant. I know you would, in front of God and everybody. I know. Oh, that's what I'm like. That would be fucking funny. And he's just like, well, shit. What do I don't know. I've been preparing for this. If he doesn't, okay, so here's another thing talking about like the Odin stuff. If he doesn't want that in, why does he have an expert on Odinism? Hold on real quick. Fear bonus. And that's fine. I know that people like this. I will be very honest. I don't care what other people's opinions are. I don't care if people think he's going to plea. I don't think he's going to plea. I think we're going to trial. Unless there's some last ditch craziness, I mean, if she did approve this for whatever reason, she should hold a hearing on this. I'm gonna tell you what she should do. She should hold a hearing on this. She should come to some form of amended compromise on what is and what isn't, and when and how they're going to be able to do this. And that's how it should go down. Nobody's offering a plea. The defense team isn't going to McClelland and saying, hey, we'll take a plea if you'll give us one. And McClelland is not offering them a plea. Well, like the Weber garage was a rumor for many years. We had the Mears barn and the Weber garage. It's been talked about for a long time. So I'm curious if something comes up. But even if it comes up exactly the way that it's being stated, then it doesn't matter because it's not Rick's DNA. So even if there's 100 blood drops in the Mears garage barn or the Weber's barn garage, no matter what it is, doesn't matter because it's not Rick's DNA. That's the problem. So you can have all this evidence everywhere. Essentially, it isn't going to matter if it's not his. Yeah, any plea would it doesn't make sense. They're not going for a plea deal. That's where I'm at with it. That's my opinion. I don't care if somebody has a different opinion. I don't care if people think he's going to plea. I mean, one of us is going to be right. One of us is going to be wrong. I feel like I'm going to be right. This confuses the issues. Okay, so I think this comes down to that how messy the discovery was and how like they don't want any snide comments from the defense team saying like, well, we couldn't find that in discovery, Your Honor. You know, Nick's saying he sent it, but we couldn't find it because of the way everything was given to us. Any reference to any PowerPoints. Here's another one. So whatever this PowerPoint was that they got and then they didn't get, and there's this back and forth. So they don't want any reference to any PowerPoints provided by the state as executive briefs, including any person or persons that were investigated by law enforcement as part of the 6-year investigation into the murder of Abigail Williams and Liberty German, that are not relevant or would tend to cause confusion of the issues or has the potential to mislead the jury in violation. Burden is on the opponent to show why this is relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by the prejudicial value. Same misquote, same thing. Now, this is PowerPoints provided by the state of their own investigation. So this would make sense. Let's say they go and interview I don't know, Joe Schmo and they put them on this PowerPoint just to go through, like, this is who we've marked off the list, this is who's there, this is who isn't. They don't want them using anything like that to prejudice the jury and just confuse them, and like, why did you go question this person, and 6 years later you went and questioned this person again, or you went and questioned this person. Now, that would be fine, but any PowerPoints provided by the state when it comes to Ron Logan, when it comes to Keegan Kline, when it comes to anything to do with the Odinism, which is, remember, they got the PowerPoint in the first go round of discovery, and then when they were back on the case and given it back, they didn't have the PowerPoint. So I think that they're encompassing anything and everything in here that they just don't want in there. So anything we looked at, we don't want you to be able to use. You can't just go ahead and use all the investigation stuff to try to prejudice the jury. That somewhat makes sense, because over the course of an investigation, you are looking at different people, right? I mean, you can understand the basis of this, but if you look at the totality of what Nick is actually asking for, it becomes absurd. So normal to absurd, like, that's where I'm at with it. Like, you can see that there's the normalcy of it. Yeah, we don't want you picking it. We don't want to spend days and days and days of you going over every person we questioned, over every person we talked to, over every person we alibied. We don't want to do that, because that's just going to confuse the jury. And obviously, we spent 6 years investigating this. There's going to be a lot of things. But like I said, if you go into the bigger part of it, which is it's all encompassing. Right. And that's exactly it. Yeah. If it was just appropriately investigated and done, it's done. How about you use evidence? How about we use your evidence to prove that you got no evidence against Rick Allen? Sound good? Well, I think what Nick is saying in this entire thing is, only let me have my evidence. They can argue against my evidence, but only my evidence. They can't present any of their thoughts or theories. They can just try to argue against my evidence, and then the jury can decide based on that. We don't want them to be able to bring in anything else. They can't talk about anything else. They can't talk about anybody else. They can literally just but they can't be mean to me, and they can't be mean to my investigators. And when I call, inmates to the stand, they can't go and try to say, hey, these are bad guys, and talk about what they've done, because that's a 404B violation. So they have to be nice to the witnesses. They have to be nice to me, and they can't bring any of their own toys. That's how this play date's supposed to go. Nick will be telling the jury that these defense are liars. He'll be telling the jury that the defense broke court rules, were kicked off, LOL. Well, I think that's one of the reasons you do it. You think that people aren't going to have heard of that? I mean, imagine the questioning when it comes to, did you, Nick asking in Vordard, have you heard of the defense attorneys? Did you hear about what they did? You know what I mean? Also, the investigators didn't investigate the Odinism good enough to prove to the jury how they were involved. I think that's why he wants it out. Absolutely. Absolutely. It is absolute proof that they did not follow up on all the leads. And I say this over and over again, too. If there was no Richard Allen, if we didn't know anything about a Richard Allen, whether he's the guy or not the guy, if we didn't know anything about it, and we were told in August of 2022 that they had lost all of this, all this video, all this audio, if we had known that there was an FBI task force who was working with Todd Click from Rushville to put together Odin reports and all of those things, what would people think if all of this stuff was never followed up on? These people were never cleared. They never went and got, think about it. People are always like, oh, the Brad Holder and Odin stuff's been around forever. Right. It has been around forever. So why didn't they clear it? Why didn't they go to his work and get the damn alibi? Why didn't they get the tape? Really easy, right? So now it proves more of the incompetence, not corruption, but the incompetence of the investigators. They don't want that in front of a jury. Because like I said, even if you just all the people on social media who are absolutely invested in the outcome of this case, and they heard that nobody was investigated, leads weren't followed up on, search warrants for cell phone data weren't actually executed. They were signed off on, never executed. if you heard all of that and there was no arrest in the case, you don't think everybody right now who's at each other's throats on social media would be on the same page and out fucking raged at what happened in this investigation? So now add him in, add Richard Allen in. All that stuff is still true. It doesn't change the fact that they didn't do all of those things. You don't know that they didn't. I don't know if that's to me, but I know they didn't. I do know they didn't. Because they said they didn't. Both sides have said they didn't. And on the stand, Nick's actual witnesses say they didn't need to. They didn't feel it was important. They didn't feel it was important at the time. Mullen, hindsight's 2020. So we know they didn't. We know they didn't follow up with any of those things. They tell us on the, not just from the defense, but the prosecutors also say that they didn't go follow up. They didn't go there. All they did was talk to the lady on the phone. People will just assume all of it was all on the up and up and at trial and that he really did it. That's, well, yeah, because they're going to sweep everything else under the rug. And that's what this is for, is to, hey, no, don't say what we did wrong. Don't say what my witnesses have done wrong. I'll see him when I see him. Sounds like how I tell my husband. I've got 7 years investigating this case from my couch. Someone owes me a new couch. This is important to me. My butt hurts from watching for 7 years. Take it up with Nick. I think that's more like, okay, let me keep going. Okay, so anyway, here it is. They're just saying, hey, we want the court to grant the following relief. Order the defendant through his counsel and witnesses to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to any of the above matters without first obtaining permission of the court outside the presence and hearing of the jury. To further order said persons to make no reference to the fact that this motion has been filed and granted, and all other relief just and proper in the premises. So he doesn't want them to go and say, hey, we were going to tell you about this stuff, but the prosecutor filed a motion that the judge granted that said that we can't. So to me, and like I said, don't confuse the fact that I don't care for Nick and his ways with the fact that Richard Allen might not be the right guy. That's not how I feel. I am going to wait and see if they happen to have anything else. This motion tells me, makes me believe, makes me think that they don't have anything else. Because if there was this quote unquote bombshell piece of evidence that they were going into court with, none of this other shit would matter. It wouldn't matter. I mean, they would still limit things. Like I said, these motions are common. But the context of what he's asking for, very different. It was the FBI that concluded that they were runes in the behavioral. Okay, so saying that the sticks on Abby's head are simply tree shoots. Okay, I don't know. I don't know why that would matter whether they're tree shoots or not. That doesn't mean anything to me. I mean, the other ones are logs and sticks. Let's be real. So they're logs and sticks. So calling them by what they are doesn't take away the meaning of whatever somebody did there. And doesn't take away the fact that there was something. It's on her hair. It's not in her hair. It's on her hair. It's not under her hair. It's on her hair. Now, did it fall down later? I don't know. It does not look like antlers to me, but there's definitely something placed on her head. The fact that we have a person who talks about placing something on her head is enough for me to go, holy shit, wait a minute, let's figure more about this out. Not just sweep it under the rug and say we don't talk about it anymore. That's the epitome of everybody saying that we just ignore the bullet. Well, you can't ignore the bullet. It's going to be there. They're going to talk about it. Now you can say how much weight you want to give it and how much you think it's going to play into it, but you can't ignore it. You can't act like it's not there. That's the same thing. Acting like these sticks were not placed on the bodies is what do you call that? There's a fucking name for this. Leave Ruckus alone. I like Ruckus. And say it does not have a lot more that we will hear at trial. Guess we will have to wait and see. That's my thing. If they did, though, if they have this big bombshell piece of evidence or even enough. Okay, so circumstantial cases. What that technically means is that there's enough pieces of evidence that you can infer the likelihood that this is the right person beyond a reasonable doubt, right? That's really what it comes down to. So if you have to leap from one to the other, then there's a problem. And this is where my confusion comes in. Because if Richard Allen actually does leave at 1:30, and there is anything on the geofencing that shows that, that's going to be very problematic. So how do you infer that he was there at 3:30 and drops this unspent round? Now if he's on the geofencing and it shows that he's there till 4 o'clock in the afternoon, we're going to have a whole different conversation. Shows guilty knowledge. Can't see him, so can't mod him. Who are you modding? He blocked me because I couldn't answer why RA defense wanted to get the search warrant thrown out. Well, because that's just part of what the defense does. This is, like I said, there's certain motions that are just made because that's part of what they do. They can't talk about the geofencing if it shows that he left at 1:30. No, yeah, nope. Mm-mm. Yeah, I got to go finish listening. I was listening to you on R&M yesterday, and I haven't got to finish that live yet. And that's another reason I've already been questioning how much evidence they have. Jay says, like, no wonder they only need 2 weeks. They don't have a lot of evidence, and they're not. They don't want the defense to have any type of rebuttal. Well, yeah, no, I like when you're on panel. Smart guy there. I like that. So what about the picture BH posted depicting 2 dead-looking girls in the woods with sticks? No, they don't want that in. They don't want that in. They think that would just be confusing to the jury because you can't even talk about Brad Holder. He's on the list you can't talk about. This is not granted yet. Like I said, she should have a hearing. Okay. Let's go through this one quickly, too. Many little YouTube commenters blocked me, but only Gray Hughes and Rufus blocked me as YouTubers. Oh. Scott. Yes, he does. Very much so. I can't go fangirling, though. I'll blush. You gonna take it? You gonna open it right now? Hold on, you guys. Radar says, T, why does she need a hearing? Surely she knows the law and the rights. Why would be the point of hashing this out? It's ridiculous, in my opinion. I think that she needs to hear both sides, and she needs to have them cite the law that they believe lets them do things the way that they want to do things. And honestly, it's the right and fair way to go about it. And that's where I struggle with, will she have one or not? But she should have one. She should. Because she should let them both have the ability to see what there is, you know, to plead their case, if you will. Did you actually see the photos? I have, yes. How do you have a hearing over this? Does she have a hearing for the defense? No, but I expect that you're going to see more motions like this coming this week and into next week. Okay, so the other one that he filed today is the motion, is his response. Nope, I grabbed the wrong one. I pulled this one up just so we had it. So the motion to suppress the accused's second statement was filed on 4/15 by the defense. And this is the response from Nick today. So the state's objection to defendant's motion to suppress the filed April 15th of 2024. There's no pretrial hearing scheduled as of right now. Nope. So she'll either schedule one for a couple of days right before jury selection, or her scheduling that she has 13, 14, 15 will be jury selection. 16 is to have the jury sworn in. She'll probably either do it then, or she'll hold it Friday before opening statements. That's my theory, is that's probably when she'll do it. So now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland and respectfully objects to the defendant's motion to suppress filed April 15th, 2024. If you guys remember, we went through this. This is the one that is the statements and the conversation that he had, that Rick Allen had with Jerry Holman when him and his wife were going to, quote unquote, pick up their car. And he said, I just want to talk to you for a little bit. And then he doesn't read him his Miranda rights. And the whole conversation, we did a whole nother live on what, you know, how to know if you're in a custodial interrogation and when you actually have to have your Miranda rights read to you. And Travis was kind enough to come up and help me with that one. So, so now this is his response about the conversation, whether it's a custodial or non-custodial interrogation. On October 26th of 2022, Richard Allen came to the Indiana State. Both sides have such typos, it bugs the shit out of me. State police post in Lafayette to talk about the return of his vehicle that had been searched. He came to the post voluntarily under his own volition. Once he arrived at the police post, he was asked to speak with Jerry Lieutenant Holman. He was taken into an interview room where he was informed by Lieutenant Holman that he wished to speak with him about the results of the search of his home, but that he was free to leave at any time. The interview room consisted of 3 chairs and a desk. Lieutenant Holman was the only law enforcement officer present in the room, and the doors were not locked, and for Richard Allen to leave, he only had to exit the interview room, travel down a short hallway, and exit through a set of doors to the lobby. None of the doors were locked or required assistance to exit. Before Lieutenant Holman spoke to Richard Allen, he reminded Richard Allen that he had been advised of his rights back on October 13th of 2024, the last time he spoke with police. Richard Allen affirmed that he understood his rights and sat down to speak with Lieutenant Holman. The interview lasted approximately 60 minutes. Pretty sure in the defense filing it says it lasts like a little over 2 hours, but I'd have to go back and look. Let me see. It's 13 pages to go through. I'm not doing it. Okay, we'll look at it. More gaslighting. Richard Allen firmly understood his rights and sat down to speak with Lieutenant Holman. The interview lasted approximately 60 minutes, during which time Richard Allen was given multiple breaks. 2 hours and 41 minutes. Thank you. I mean, that's a pretty big difference in time. So they either have a 2 hour and 41 minute tape or they have a 60-minute tape. I don't know. Or do they cut out the rest? He was given multiple breaks where Lieutenant Holman left the room, leaving Richard Allen unattended. At one specific break, those are not breaks for Richard Allen. If he's in the room, he's not on a break. Just FYI. That's a break for Holman. He's the one leaving the room. I mean, do you ever like say, hey, I'm going to take a break at work, and then your boss leaves, and then and you stay there? Like, this is stupid. At one specific break, Richard Allen left the interview room to use the restroom and go outside to smoke. And then he returned to the interview room to continue the discussion with Lieutenant Holman. If that's true, then that would be considered a break. At no time during the interview did Richard Allen get up to leave. Nor did he just, well, he did. At no time during the interview did Richard Allen get up to leave. Well, he did if he got up and left. So this is, I don't know. Get up to leave, nor did he display signs of distress or undue influence. I mean, Richard Allen left the interview room, and then the next sentence is, at no time during the interview did Richard Allen get up to leave. I don't know. You guys, semantics, maybe? I don't know. They had his car, right? I mean, he was there with his wife in his wife's car, but at no time did the individual Richard Allen get up to leave, nor did he display signs of distress or undue influence. Richard Allen sat through the entire conversation with Lieutenant Holman and participated in the exchange even after saying he was done talking. That's not all. That not all interviews by law enforcement are considered custodial interrogations. We know that. We went through what is a custodial interrogation and what the requirements are and how to know if you're in one. In order to be a custodial interrogation, the person's freedom of movement must be so curtailed that the person is under the same inherent coercive pressures as those at issue in Miranda v. Arizona, meaning that the restriction of movement is at a level akin to an arrest. The determination is based on a totality of objective circumstances, and there is no bright line rules. Simply because a person is questioned in a police station does not mean that the interview is a custodial interrogation. Miranda warnings are required only in those situations where the encounter is a custodial interrogation. I am not. Would you like my phone?
Yeah.
Okay.
So Daddy's not here. I have no. And Kaylee says, and you remember when Kaylee says, like you said, you want to play by yourself or play with someone? And you said play by yourself.
Mm-hmm.
So and Daddy's gone, so I can't have his phone.
Okay, you can have mine. You're welcome.
Thank you.
Simply because a person is questioned in a police station does not mean that the interview is a custodial interrogation. Miranda warnings are required only in those situations where the encounter is a custodial interrogation. Let me see if I still have that up. I probably don't have it up, but I could probably pull it up pretty easily. So just a little quick review here. What a custodial interrogation is. Let me see if I have the other one that I used. He's a Sour Patch Kid. He's like, first he's sour, then he's sweet. You just never know what you're going to get with that one. I don't know, maybe it's a third kid syndrome. But that one was sweet. Questioning, express or implied, initiated by a law enforcement officer after a person has been deprived of freedom of action in a significant way. Okay, let's go back. He's right, though. There is no bright line rules, but there are some definite recommendations on when and how to go about reading the person their Miranda rights and why you should. So Miranda rights, Miranda warnings are required only in those situations where the encounter is a custodial interrogation. But it is what a reasonable person would think is a custodial interrogation, that what a reasonable person would think that they could or could not leave. And there's a couple things that he even brings up here that I'm going to point out on why, if we think Richard Allen thought he could or could not leave. If the interview is custodial in nature, then the court must determine whether or not the confession was voluntary. Now, this is taken over the internet today. He confessed to an ISP officer. No, that's not necessarily what that means. It's any type of statement, admission, anything. So when he says, yeah, that's my gun, and yeah, I don't let anybody else use it, nobody else touches my gun, that's the same thing. The admissibility of a confession is controlled by determining from the totality of the circumstances whether the confession was made voluntary and was not induced by violence, threats, or other improper influences that overcame the defendant's free will. Factors that the court can consider when determining voluntariness include whether or not there was police coercion, the length of the interview, the location and the continuity of the interrogation, along with the defendant's maturity, education, physical condition, and mental health. The critical inquiry is whether the defendant's statements were induced, defendant's statements were induced by violence, threats, promises, or other improper influence. A confession is voluntary if, considering the totality of the circumstances, the confession is the product of a rational intellect and not the result of physical abuse, psychological intimidation, or deceptive interrogation tactics that have overcome the defendant's free will. And anybody's going to say, well, how do you know he didn't confess? Because if he had confessed, we would know that by now. We would know that that one of the confessions was actually done in the what they consider a non-custodial interrogation. Well, his SOP would disagree. It all should be taped. And he should have been read his Miranda rights because he was in a custodial interrogation. And I think the easiest way, like I keep saying, to prove that is, where was the car? Was the car ready to go? They were there to pick up their car. Was the car ready to go? Answer me that. If the car's not ready to go, if the car hasn't even been brought there, if the car is still in the evidence bay, then the car ain't ready to go. Was the paperwork signed that said the car had been released from evidence? Tell me any of those things, and I can't wait. This is one of the reasons I'm like, I can't wait till trial. Tell me one of those things. Where was the car? Yeah, where was the car? Where's the paperwork that shows the car was being picked up and that they were ready to release it? Because from my understanding, and I cannot prove this, but from what I've been told, and you can take it as just hearsay at this point, or just all willy-nilly, they still have the car in their possession. I don't know if the car was ever actually released to Kathy Allen. If it was, I've not seen any proof of that either. So where was the car? Was the car ready to go? Because he knew he was going there to pick up his car. Holman knew he was going there to pick up his car. Where was the car? It was not. It was not ever. See, that's what I'm saying. I don't have any documentation to prove that, so it is what it is. But from my understanding, they still have the car. Like I said, where was the car? Because they didn't turn it on yet, right? Hyper Prof. Oh, Carrie had a question. Let me see. Where's Carrie? Let me scroll back up. Most of the time, I'm not looking at the chat when I'm reading because it's on a different screen. So if I miss something, it's not intentional. The other filing today on my case by Gull states that all the rules and expectations and says for explaining it to court will blank. There will be audio recording done. Okay, so that's what everything will be recorded. What she's saying is that it will be recorded for the record, but it will not be available to the public. Like, we can't go request it. We won't be able to request the audio. We won't get to hear any of it. So, but it will be recorded, but we just don't get to hear it. So there will be audio, but not ours. Not for us. Okay, go read the second to last long-ass filing. Yeah. Johnny says, just think about if his confession was real, why is there even a court date? Don't you think they'd be cutting deals by now? For sentencing that would have come by now and said they cut a deal? Well, we heard the rumors that Nick had offered a plea. It was all rumor, though we don't have anything to back that up. So not all the time is jury selection put out. Sometimes they don't put that out. So that one's not as bad. I mean, I'd be fine if she wants to keep her jury selection to herself and then just give us the damn trial. That's really more important. That it is required for her to release the audio of jury selection. That would be interesting. Secret spot pins, y'all. You said, Sleuthie said not so fast, so I slowed down, and now I don't know what I'm slowing down for. So I think that this is just, like I said, the defendant's statements, anything that he said. So anything that he said while he was in there, because they want the entire thing thrown out. A jury box full of Odinis. Yes, it is acceptable. Correct. Okay, we'll keep going, and then I'll watch for Sleuthie's comment. The fact that there was police deception, or the fact that part of the interview is not recorded, does not render the statement inadmissible. The Indiana Supreme Court has held that the police deception does not automatically render a confession inadmissible. Further, the court determined that advisement of rights is not part of the interrogation and need not be part of the recording. This is why they typically have it written out and there's a waiver. Hi, Charmaine. Sleuthie's got her cape on. Don't worry, that's just Sleuthie looking some shit up. So yes, they can. They can be deceptive. They just can, unfortunately. That first, the state does not believe that the interview by Lieutenant Holman at the Indiana State Police Post was a custodial interrogation that required Miranda advisement of rights. Richard Allen arrived in his own vehicle in the company of his wife at the post. Well, he was there to pick up his vehicle. He voluntarily sat down with Lieutenant Holman to discuss the findings of the search warrant. He was advised that he was free to leave at any time. Now, this is what I want you to pay attention to. The location of the interview occurred in an office space that contained 3 chairs and a desk, with Lieutenant Holman seated at the desk with his back to the door, and Richard Allen seated next to the desk. Richard Allen entered the interview room by going through one door from the lobby and a second door down a short hallway to the interview room. Okay, let me back up here. So right here. So the location has 3 chairs and a desk. Lieutenant Holman is seated with his back to the door, and Richard Allen is seated next to the desk. Now, trying to visualize this, I see, and hopefully, they're going to play it in trial, and we'll actually get to know how it was actually set up. But hold on, let me pull this up. For me, so if anybody doesn't know my history, I was a retail manager for over 20 years. Now, when we had any type of interaction with an employee and brought them into the office for any reason, where do you think we had to sit? We had to sit on the opposite side of the door. The employee had to always feel that they were free to leave. A retail manager. Yeah, I was. For a long time. Long time. So the reason being, the person who is the employee would feel trapped and unable to leave if they were not the one closest to the door. You have to let them be able to feel that they can walk out of the room at any time. Otherwise, you make them, yes, Jeremiah, exactly. You make them feel trapped because they have to get through you to leave. So, like I said, I can't see this, but the way I'm visualizing it is Holman is seated at the desk with his back to the door. Richard Allen is seated next to the desk, which means he'd have to go past Holman to get out the door. So we were never allowed to do that. And I'm telling you, that was for reviews, it was for write-ups, it was for anything. So Richard Allen entered through one door from the lobby, second door down the hallway. The door was closed during the interview, but was not locked. Okay. I don't remember them saying it was locked, but Lieutenant Holman asked Richard Allen if he remembered his Miranda rights that other detectives had read him 13 days prior, and Allen said yes. Lieutenant Holman documented this advisement, and it was also observed by Indiana State Police Detective Dave Vito, which is interesting to me because apparently he was not in there. Hold on. In finding the thing for T, I did find an answer to my question. He was arrested on camera. Okay, hold on. The state police never turned over the vehicle. Oh, here it is right here. The state police never turned over the vehicle to Kathy Allen after Rick Allen was arrested. Returning the vehicle to Rick and Kathy was merely a subterfuge to get Rick to the police post to be interrogated. So where was the damn car? I think that would answer a lot of questions. Whether they actually knew he was going to be staying there or not. Tell me that they didn't know they were keeping him. Tell me that him saying that all he had to say in here was that it was my gun and nobody else could touch it. That's the quote unquote confession. In my opinion, we've not heard it. In my opinion, that's what it was. Worked for Meijer in Michigan for 17 years. I hated retail. I always tell everybody, like, so I was, my dad was a cop. My mom was a retail manager. When I got out of high school, I went to college. I wanted to be a homicide detective. I got a job to help pay for college in retail. It was like a temp job. It was super, just going to help pay some bills. It was super easy. The boss liked me a lot and promoted me. And I made really good money. And I was like, why the hell am I going to go to college? This is me, 18 years old. Why the hell am I going to go to college if I can just make this kind of money by not even having a degree? So I was like, I'll just go this route. And then I got promoted and I got promoted. And so I stayed and I went from retailer to retailer. And then when I had my youngest son, who's now 7, I was like, you know what? There's one thing I never completed in my life. There's one thing I never finished, and that was getting my college degree. And that's when I decided to go back to school and finished my degree. And now here we are. So it's ironic because I wanted to follow in my dad's footsteps, ultimately followed in my mom's footsteps, left that to try to have some type of little bit of my dad's footsteps. And now we're all here. Yep. But now we're all here. So exactly, this was was he watching from the other side? That's what I would be curious about, because remember, Holman's the only one in the room. So where is Vito? Where's Vito that he hears any of that? I wasn't with American Eagle. I was with Walmart. I left Walmart, went to Toys R Us, left Toys R Us, went to Home Depot, left Home Depot, and went to Jenny Craig. And then when I left 7 years ago, God, I can't believe it's been that long, I left Jenny Craig. The interview was approximately 60 minutes long, in which Richard Allen was given multiple breaks where Lieutenant Holman left the room, leaving Richard Allen unattended. Okay, well, the defense isn't arguing that point. What they're saying is that Holman said, stay right here, I'll be right back. Essentially like, don't go anywhere. So during one break, both Lieutenant Holman and Richard Allen left the room for Allen to use the restroom and go outside to smoke. Not once during the interview did Richard Allen get up to leave the room. Nor did he display signs of distress, undue influence, or express a desire to leave the room. Richard Allen continued to sit and participate in the exchange even after saying he was done talking. The statements of Richard Allen were voluntary. See, this is why I go back to, I think he uses templates a lot, and I think that causes some confusion. But these are the statements, and we know from the PCA what statements that were made there that got him arrested, right? that even in the midst of Alan saying, I'm done, or I'm done talking, the totality of the circumstances would lead to a conclusion that not only was the interview such that it was non-custodial, but that the statements of Richard Allen were also voluntary and not the result of law enforcement coercion. I smoked pot with Jenny Craig. Did you really? Yeah, he definitely uses somebody else's templates. Did RA sign a Miranda waiver on the 13th? He did, yes. Each state might have a time frame for that waiver to be valid so that his rights don't have to be read again and again. I think my state covers 15 days. So this was a conversation, Goose, that we were actually having and trying to figure this out, because he's not interviewed in the same location. He's not interviewed by the same department. And then there's 13 days in between. So it's different investigator, different department, different location. So what does that do to this time frame? That's what we were trying to figure that out on one of the last lives. And I don't have a good answer because I do think it's different. In trying to Google it doesn't work. So wait a minute. Didn't NM say earlier that one of the times Holman had went out, RA just went to use the restroom and went to smoke without him? Does he say he went out here with him this time? I don't know if it, I don't think he's actually saying he goes with him. He's just saying Richard Allen left the room for Allen to use the restroom and go outside and smoke. I don't think the Holman's with him. I don't know, though. Hey, Teresa. I probably did. Okay, let me see. Richard Allen's demeanor in the interview is that of a person who is not under undue influence or coercion. See, there is no fine line. I mean, there is no like black and white line here that says one way or the other. It's going to be open to interpretation, but I mean, isn't it going to be what Richard Allen says he felt? He's the only one who could say that, no? And if Richard Allen felt coerced, I don't know. I don't know how that's going to work. Even when Lieutenant Holman raises his voice and makes accusations directed at Allen, Richard Allen remains calmly seated, continues to answer questions, does not leave the room, and never attempts to leave or express a desire to leave. I also think that's interesting that he sits there calmly. But we know that he got a little fired up because he was like, you're going to pay for what you did to my wife or whatever. Further, it is clear that Richard Allen is aware of his rights and understands his rights because at one point during the interview, he tells his wife that requesting an attorney would terminate the interview. Now, this was interesting to me because Kathy Allen is not in the interview room with him. So when does he talk to her? When is he telling her in this interview where she's not at? And the other thing, she's actually supposed, you know what? I'm almost positive that she's talking to Vito at this time. Let me see if I have that open. I don't because I closed everything. Damn it. I'm almost positive that she's talking to Vito during this. Shoot. So when does he say this to his wife? I don't know. That even if this encounter was determined to be a custodial interrogation, the Miranda advisement was given and was sufficient to advise Richard Allen of his rights. It did not need to appear on the video recording to be valid. However, Lieutenant Holman reminded Richard Allen of his Miranda rights and ensured that Richard Allen understood those rights before he started the conversation. Further, Richard Allen was free to leave at any time, but chose to continue the interview with Lieutenant Holman even after stating he was done. Well, this is going to go to, they don't believe what Lieutenant Holman says. They don't trust him. So I think that just saying that Lieutenant Holman said this isn't enough. I think that's the problem here. And that's what the defense keeps trying to prove over and over is we can't just blindly believe what these people say because they lie. So you can't just take their word for stuff. It's not, they have a history of lying. But now in his motion in limine, he's making sure that they can't call that out. You can't call out any history of anything bad like that. You can't say anything bad like that. So, and I know, and this is one of those things where I say, like, both sides, this comes down to trust. Some people are going to say, Nick isn't lying. Nick's telling the truth. Holman isn't a liar. He's telling the truth. So you do trust him because it's in his report. I don't know. I don't know. Understood those rights before he started the conversation. He was free to leave at any time, chose to continue the interview with Lieutenant Holman even after stating he was done. He says he was done, but he can't actually walk out of the room. How does he walk out of the room? How does he try to go to leave if the door is being blocked? I would wonder. Does he never stand up? Maybe he never stands up to leave. That's one of those. We'll have to see the tape. The facts in this case are quite distinguishable from the facts presented by the defense. And the court emphasized the circuitous, I always say that word wrong, path, it's like circular, that the defendant would have to navigate if he chose to leave the interview. The court described it as a labyrinth exit route with many obstructions to egress. That's State v. ER. This would, in the court's view, greatly discourage a suspect from leaving the interview room. Like they don't know how to get the hell out of there. They don't even know where to go. In contrast, Allen's exit involved a short walk with multiple hallways or elevators to navigate. Further, the ER court emphasized the impact of having two officers present during the interview as opposed to one officer, which occurred in the interview of Richard Allen. Well, then how did Vito hear anything? The facts of this case are more akin to State v. Diego, which I actually think that I had that pulled up too, where although the interview occurred at a police station, Diego was not under arrest or in custody. He arrived at the station on his own. He was advised he could leave at any time. The path to the exit did not require assistance, and he was confronted with case facts and evidence, some of which was not true, after which he made incriminating statements. In Diego, the court determined that given the casual atmosphere, exploratory and conversational line of questioning, and relatively unimpeded pathway to the room, the totality of the circumstances were not indicative of a custodial interrogation requiring Miranda. Well, this because the exploratory and conversational line of questioning, which is what we went over, why the defense put the certain quotes in that document. I can see you, Scott. They chose those quotes to show that this was not just a casual conversation. It just wasn't a laid-back conversation. You have Holman who's yelling at him and saying, "I know you did this." He's saying, "No, I didn't." He's saying, "I'm going to prove you did this." It's not just a casual conversation. That's why they chose those statements by Holman. That with regard to the voluntariness of the statements made by Richard Allen, this case is similar to Hodge versus State, where Hodge stated, "I don't have nothing to say," in response to the detective confronting him with facts and evidence of the crime. The detective pushed Hodge to explain or tell the truth. The court deemed that her statements did not unequivocally invoke her right to remain silent. Then even more consistent are the facts in Light v. State, wherein defendant was interrogated for 4 hours. Miranda warnings were given but could not be produced on the recording, and Light argued that his inculpatory statements were admitted in violation of his right against self-incrimination. The court applied the same standard as the U.S. Supreme Court, focusing on two areas. One, whether coercive police activity violated the U.S. Constitution, and two, whether the defendant's will was overcome by such coercive activity, with one being a necessary prerequisite. The court deemed that it is important to determine whether the statements would not have been given but for coercive government influences. Light argues that his lack of experience with police procedures, the privacy of the interview room, coercive psychological techniques by police, and false legal advice, among others, along with his lower intelligence and his mental state, indicate that he was overborne by police coercion. The court ruled that his interrogation was only 4 hours. The evidence showed Light was of sufficient intelligence to understand his rights, and officers lying about certain evidence against Light, and even questioning that positing Light's guilt in every question and storming from the room when the interviewer did not like the answer. Okay. In this case, Richard Allen can be observed to remain in the interview voluntarily. He was not under arrest or restricted in his freedom of movement. He was afforded multiple breaks. He continued to engage in the exchange even after expressing, "I'm done," without coercion or undue influence. Therefore, his statements, whether true or false, were voluntary and therefore admissible based on the totality of the circumstances. Wherefore, the state argues that the encounter between Richard Allen and Lieutenant Holman was a consensual encounter, thereby making Richard Allen's statements voluntary. Further, if the encounter is considered a custodial interrogation, which the state disputes, Richard Allen was advised of his rights prior to the interview, which he waived by participating in the exchange, despite Lieutenant Holman becoming confrontational and accusatory or mischaracterizing evidence, lying. Further, the state argues that the totality of the circumstances supports the conclusion that Richard Allen was not overcome by acts of coercive governmental influences. Wherefore, the state would ask the court to deny the defendant's motion to suppress statements filed on April 15th without a hearing. They don't even want to have a hearing on it. They're just like, deny it. He's like, just go ahead and deny it without a hearing and for all other just and proper relief in the circumstances. He's like, just do what you do, Gull. Just do what you do. Just deny it. At 14 days, they need to have their Miranda signed again. So this seems to be right around 14. I've heard 13. I've heard 14. I've heard 15. I'm not sure if it's different per state, but like I was saying a little bit ago, the biggest thing I was trying to figure out is, does it matter what law enforcement agency, like what department, what officer, the fact that you're in a different location, even though it's the same state, you're in a different location, does none of that matter? And I can't find anything solid that tells me one way or the other whether it does. So I don't know. But ultimately, even when I read the suppression motion, I do not believe she's going to suppress it. I believe it's going to come in. And I think that this is just, we're reading these for insight into what both sides are thinking about the same thing. So that's where I'm at. I don't think that we're going to see a suppression of his interview with Holman. I just don't. I don't think. I'm sure that one she might just go ahead and go, okay, based upon the state's reply, the state's answer, I will deny this without a hearing. I put the Indiana sentencing guidelines link in the Facebook Delphi chat, and it got thrown out saying it looks like you helped arrange and encourage sexual activities. Yeah, I don't know what it is about the community chats, but like it won't let me post links in there either. I tried to drop my Prezi link in there, and it's like, you're spamming. I don't know why. I don't know if it's a setting I have on them. I have to go look because I don't understand. It doesn't like links. I don't think Allen confessed to anything in this interview. The motion to suppress is to bring to the surface what Ellie did, right, T? Okay, so my opinion on that motion to suppress was to call out Holman and to set a foundation on how Holman acts as an officer, as law enforcement. I think it was done intentionally that way. I don't think that they thought they were going to actually get it suppressed. That's my opinion. That is, I have only my opinion based on that, to base that on. So I take it or leave it. That's totally up to you. I just feel like the whole purpose was to just show Holman's true colors and to get that on the record. Another thing is that those are the types of things that they have to look at. And when I say, like, I know you get, it's like redundant. There's certain things that happen in every hearing. These motions to compel evidence, totally normal. The motion in limine, totally normal. Now, the content of Richard Allen's are more intriguing than others. The motion to suppress, certain parts of conversations, interviews, interrogations, or suppress, certain evidence. The motions they're just very, very common. The motion to get the search warrant quashed. You know, that's why I say, like, I don't take them overly seriously based on that the motion is filed. It's more about what they're saying inside the motions that you go, wait a minute, how does this even make sense? I don't know how. I'm trying to say that as simple as possible. I think Sleuthy said it best earlier when she was like, the motions are normal, but the rest is fuckery or something like that. I don't remember exactly what she said. I should have actually left it on the screen. All right, let me see. Holman wouldn't let him ask for a lawyer, just like Fortson, 7 separate statements. And Fortson did ask for an attorney. He did ask for an attorney, and he kept talking to him. But he didn't, it wasn't necessarily asking him questions. He was just making statements. Let me see. Catastrophe says, however, isn't the EF or ER case they cited related? The ER case that's cited in the response and the answer is also cited in the original motion from the defense. Yeah. Yeah, no, I don't, it's, when we read over, like, what does how to know if you're in a custodial interrogation, it came to, does a reasonable person think they can leave? Is it even on tape or audio that Holman asked, does he recall the Miranda, or is it just believe it because they wouldn't lie? Correct. It is not anywhere that he asked it. It's not on audio. It's not on video. What Nick is saying in his response is that Vito heard it. So Vito backs up the fact that Holman said it. So even if you think Holman's a liar, Vito also heard it too. Right. That's why, like, I keep trying to say, like, even if Delphi is the only case that you follow, because I know there's a lot of people who, like, have one case and, like, that's kind of it. They just happen to get invested into one. It's still important to listen to certain other things in other cases so that you understand why things happen the way that they do. And it's tough because every state is different, and so you have to kind of try to figure out, like, what state is, what that state does. Yeah, there's no report from Vito. Not that anybody knows of. But I'm telling you, I believe that Vito was talking. I have to find that. I believe Vito was actually talking to. Let me see if I can just get it up real quick. CJ would be so proud. Hold on. I don't know if it's gonna. I don't know if my internet's gonna allow this to load. It may not. If there was a way to expose everyone that was corrupt in this case, that their punishment would be to experience the same treatment as RA, do you think they would come clean? Oh, if they got caught, you mean? No, it's in here. It's in the thumb drive map, taking us back to Woodhouse. Oh, she's with Harper. I apologize. It wasn't Vito. Kathy Allen is at ISP with Harper. It doesn't have a time, so it could technically be after that. But on the 26th, he's being interviewed at ISP by Holman. She's at ISP, and she's being interviewed by Harper. I thought it was Vito, but her brother was actually the one being interviewed by Vito, which is also interesting. Then I wonder what time of day that was. And then his mom is interviewed the same day. Hmm. 2 weeks ago was happening to me anytime I had the word ISP in it. It's weird, yeah. The beginning of it was gone. Yep, just either not turned on or purposely deleted, according to the defense. So that the video was just not turned on or purposely edited out. I didn't think it could get worse than the prosecution spin that Rick was eating his paperwork because he didn't want anybody to see all the evidence against him. Hey, Junior. I know. It's disheartening. I know it is. Can you guys see that okay? Yeah. Anyway. So I don't know. What do you guys think? What do you guys think of the motion in limine? What's your thoughts? Think it's a load of shit? You think that he has a leg to stand on and that he should be able to have none of that mentioned whatsoever at all? I mean, at the end, he kind of throws in the, oh, just, talk to the court about it first. But this one right here. Either directly or indirectly to any of the above matters without first obtaining permission of the court. It's absurd. It's BS. I can tell you, I will go listen to some pro-prosecution people or even the pro-Richard Allen is guilty people, because I also don't think that they go hand in hand. But I'll go listen to them tonight, and I'd love to see how they think that this is, because this is like, like would you guys say, like, you reach for the moon and hope for a star or something like that, or you reach for the stars but hope to land on the moon? I think is the saying, something like that. Well, he wants to control. He wants absolute control over what the jury is able to hear. No, I didn't, Radar. I didn't see him this morning. Was he live this morning? Who's missing from the list of who not to bring up? I don't know if anybody. I mean, not from the defense theory, no. Thank you. Yeah, aim for the moon. If you miss, you'll still land among the stars. See, knew it was something like that. He doesn't have a leg to stand on, but Gull will approve it anyway. Innuendo, inference, direct, indirect, wild. Hey, Danielle. So beyond effed up. Charlie Adelson's defense was the most absurd thing one could imagine. The Latin Kings on a payment plan. But they let them do it. Right? I think Saturday Night Live could do a skit on that filing without changing a word. I think someone should report him. Marijuana is illegal in Indiana. In fact, they are prosecuting. It's so silly. It's so silly to be prosecuting for that. But whatever. Clyde Hope says, yep, ridiculous. I think there's a dark cloud over this case. I still can't say if Richard is one of the killers or was just there or part of the pedo ring. Hopefully we'll see the truth. I hope so. I hope so. I hope so. And I know maybe I'm naive in my I really hope so. All right, let me see. I lost you guys. I lost what tab you were on. I couldn't find you. Lost you. Couldn't find you. Oh, look at Letitia Stout's defense. He was doing a live. It was going to be a short one because I know that he had other things that he was planning on tonight. So he did Karen Reed all day. Got arrested for Delta 8. True story. I live in Indy where the real shit is outside, out in the open, everywhere, and they do nothing. Yoder and Doolin framed girl I was with for gram of Delta 8 bought at their gas station. They said it's standard. Bob and I said it's standard to go to for everything. See, like I said, the motion itself is standard. I just think it's incredible. Sorry, I keep yawning now. I just think it's incredibly crazy that they just I think for me, I'm more concerned that once Nick writes it down, that there's such a Gull could just go, okay, sounds good. That's so concerning for me, more than them just doing the whole saying of the reach for the moon and land amongst the stars kind of thing. Like, that's where I'm at with it. You just don't want him to talk about anything. Like, what do you want? And I haven't obviously got to listen to what they said, but Nancy, did they happen to mention whether they think that Gull will have a hearing, or what do they think that she'll do? Did they happen to mention what they think the thought, or what their thoughts are, what their final thoughts were? I'm still going to go listen to the replay, but just curious for the short version. Is it even legal to ask that evidence showing who was at a crime scene be excluded from court? Well, they don't want to talk about Ron Logan, and it was his property. He wasn't feeling too well? Okay. If it was anyone else, then I wouldn't be concerned. But this, I think that's where I'm at, my King of Kings. That's where I'm like, ugh. It's kind of disheartening. That's the disheartening part. Do you think Woodhouse plea agreement filed today will affect RA case in any way? I don't. So one final thing that I would like to get your guys' thought on. Hold on, let me see what Nancy said. They didn't like it, but this happens all the time. Allie thought she would have to do a hearing. Bob thinks she will rule against without a hearing. Really? Bob thinks she'll rule against it without a hearing. He must not be feeling well. That's interesting. It's a weed, Julie. Weed. The ganja. The Mary Jane. I think she would have to have a hearing, because I think that she's going to make some. If it wasn't Gull and it was just a regular judge, my initial thought would be there'd be a hearing. She would go through. She'd have them make their arguments on each part and why it should or shouldn't be brought up, or how it should and shouldn't be brought up, and then she would come to like an arrangement on when, how, what, who, that kind of thing. I'm really surprised that Bob thinks that she'll rule against it without a hearing. Standard motion, but very broad in general. Typically ask for more specific information they want left out. Yeah, they're just like, nope, just get rid of all of it. We don't want any of it. We don't want anything. And then I've not ever seen one, and so I would be curious what Bob thought about the "don't say anything about me" part, the very first one, the no comments and personal attacks on the attorney. Bob was delusional with a fever. So, well, I mean, I guess we'll see what she does. But here, my final question for you guys before we wrap it up for the night. What do you guys think about this person right here being on this list? Keegan Kline. They don't want the defense to talk about Keegan Kline, because there's a lot of people who have still stuck with that. They think Rick Allen is the guy, but he has some tie to Keegan Kline or that whole pedo situation. So, and Keegan Kline was at the Wabash River search. We heard that, and that Keegan Kline went to Grissom Air Force Base, and then he cut a plea deal. So what do you guys think of, they don't want Keegan Kline brought up? Does that mean to you that Keegan Kline has nothing to do with anything? Does that mean that anybody who's thinking that Keegan Kline is going to come in as some confidential informant? That he was going to come testify against him? What is this? What do you think this means? What do you guys think? I think so, but interesting. No KK. Yeah. Why do you think he's not on there? Or he's on? Well, he is on here. Why do you think they don't want to talk about him? I've said KK was involved all along. Catfished girls to be there for a group of perps. So K-Bird, then great. Then my question purposely goes right to you is, what do you think of them not wanting to talk about Keegan Kline then? Keegan Kline not being involved. No, KK is definitely involved. Nancy, same thing. Oh, CJ wasn't well. Jerry is actually Tony. His name is Jerry, but he goes by Tony Kline. It's Keegan's dad. But I mean, if this goes to motive or goes to a tie-in to this bigger ring of pedos, Keegan Kline would be talked about because he's part of the case. Because he has a connection to the case. But if what I'm saying is if the state is using Keegan Kline as a witness or to show that there's a tie-in, and that's a social media theory. That's a social media theory that people are like, no, we're going to see Keegan Kline. The assumption would have to be that KK knows something that points to someone else or points directly away from RA. But I think it goes kind of, against the whole the social media theory that KK is involved, and he's going to come and testify. From my memory, the D hasn't brought up KK in any filing, so his name on this list is suspicious to me. Have they even brought up Ron Logan besides? I'm getting tired now, so my brain isn't going to start. It's going to start going bleh. Have they even brought up Ron Logan besides the fact that he was the property owner? Libby was talking to KK, so not mention her. Well, I have a theory on that. That I don't think Libby was actually ever talking to KK. I don't think Libby actually had any interaction with him. That's my theory. I think that the other girls are the ones, the Breeze, the Hopes. I think they're the ones who were actually talking to Keegan Kline. That's my theory, though. And then once anything out that gives doubt, it was RA. Okay, so that it doesn't make a lot of sense to me because he actually charged him, and I'd have to go pull that back up to be able to read the exact charge, but he charges him as being a part of something. Ah, shit. I'll go pull it up. Mez! KK snitched. Then why not talk about him? If KK snitched, why aren't they going to have him on the stand? KK's going to be on the stand then if he's a snitch. Oh, I don't know. I don't know. Nobody, nothing. I don't know. I don't recall that being a tie together, but KK was a distraction. That's what I think. I think he's just a piece of shit, but I don't think. Yeah, Kelsey, Bree, Hope, DeMello. I think part of KK's deal is that he doesn't have to testify. Wouldn't part of KK's deal be that he does have to testify and that he gave the tip or that he was one of the confidential informants? And that's how they got whatever they got? Yeah, if you don't talk to the clients at all, it leaves all that catfishing is gone. That whole social media theory that they were catfished and brought there is gone. I agree with you on the ring information on that. I believe they're trying to omit KK from being discussed because he's a potential third party for the defense to blame. But I mean, they already have, they're charging him as that there could potentially be other people. Without a testimony, nothing means anything. And obviously, if he's going to be a witness, he has to be discussed. I don't know. I just find it very interesting that he's listed here, because it kind of goes against everybody thinking that Klein was involved. Right, which means he's not going to be a witness. That's my thought. That's just my thought. But it's Tony Klein that has a criminal history with crazy stuff, and no one has proof he Allens don't know the Kleins. Yeah, I've heard Sleuth Intuition talks about that he's got some local people that he's talked to that say that they do know each other, but there's nobody that has any proof. Then there's also the rumors that Richard Allen knew Ron Logan, and then there's also the rumors that Ron Logan knew Brett Holder. So I mean, but that nobody can prove any of them. But it just, like I said, I wanted to bring it up because I thought it was interesting, because I'm like, wait a minute, does this take away the fact that Klein was involved in anything to do with Delphi? Or does it mean that he is and they don't want to talk about it? I don't know. To me, it means that he's not testifying for the state, that he didn't cut some deal. What happened to the cell data from the 13th to support the timeline? Did they just never get those searched, or did they lose the reports? Well, the geofencing, Nick doesn't even want them to be able to talk about the geofencing. He wants the defense to not be able to talk about any of the geofencing stuff. But I feel like they already opened the door with the way that the charge is. I don't know where. I just closed a bunch of shit. Now I don't know where any of it is. Let me see if I can find it real quick. No. Hmm. I don't remember what the charge is off the top of my head, so I was trying to find the paperwork. And then motion to compel, answer to suppress. I literally just had it open today too, so that kind of sucks. But the way that the code is written is for the ability of other people, and it talks about it doesn't matter whether those people have been identified or charged. My King of Kings, I can't. I don't. Hold on, you guys. You see Keegan Klein running down he's not going down or up any hills. If we're looking at the aspect that he was a child predator, we know there was basically a serial killer. Bunch of Klein stuff is sealed. Yep. It's a list of Nick's biggest fears. All right, well, I mean, it's the 29th. We've got jury selection on the 13th. I mean, it's like around the corner. I don't know. There's still people who think that's going to get pushed out. I don't know. I feel like we're getting really prepared here. Anything can happen, though. Anything can happen. All right, I'm going to wrap it up and go cook some dinner. Thank you guys for hanging out with me and going through the documents. I'll go catch Bob's replay while I cook, see what he has to say. He must be delusional. He thinks that she's going to deny this. Wait, does Bob, Nancy, did Bob think she'll deny? I wonder if he's talking about this one. I wonder if he's talking about their motion to suppress the second interview. I don't know. I'll go figure it out. All right, you guys. Thank you guys for hanging out with me. As always, I know you guys have 1,000 other places that you could be, and yet you choose to spend your time here hanging out with me. I appreciate each and every one of you guys, and thank you guys for the help and putting me in the right direction with certain things that sometimes I can't find. I'd be lost without you, for real. So go enjoy the rest of your Monday. I will see you around the YouTube streets probably later tonight, and if not, we will be back tomorrow. Have a good one.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no one